The courts in the Republic. It has already been pointed out that the courts in the Republic are divided into superior and lower courts. The most important superior courts are the Constitutional Court, the Supreme Court of Appeal and the High Court. The most important lower court is the Magistrates' Court. 1.3.1 The Constitutional Court. The Constitution's 17th Amendment Act of 2012 amended the Constitution to provide that the Constitutional Court is the highest court in all matters. Before this amendment, Section 176(3)(b) of the Constitution stipulated that the Constitutional Court could only decide on constitutional matters and issues associated with constitutional matters. After the amendment, the Constitutional Court is no longer a specialist court dealing only with constitutional matters. However, the Constitutional Court still has exclusive jurisdiction as a court of first and final instance on the matters contained in Section 167(4) of the Constitution. The Constitutional Court consists of the Chief Justice of South Africa, the Deputy Chief Justice and 9 other judges. The seat of the Constitutional Court is in Johannesburg, but if it appears to the Chief Justice that it is more convenient or practical or in the interest of justice to hold its sitting at a place other than Johannesburg, it may hold such sitting elsewhere. It is important to remember that any matter before the Constitutional Court must be heard by at least 8 judges. 1.3.2 The Supreme Court of Appeal. The Supreme Court of Appeal, which, before 1997, was known as the Appellate Division, is a court of appeal for the High Court and its various divisions. Its appeal jurisdiction is unlimited, with the exception of matters within the exclusive jurisdiction of the Constitutional Court. Since it is a court of appeal for the various divisions of the High Court, it has jurisdiction to hear appeals on matters which fall within the jurisdiction of this court. The Supreme Court of Appeal consists of the President of the Supreme Court of Appeal, the Deputy President of the Supreme Court of Appeal and as many judges as are necessary in accordance with the prescribed criteria, and approved by the President. The seat of the Supreme Court of Appeal is in Bloemfontein, although the court may sit elsewhere if it is more convenient or practical to do so by reason of exceptional circumstances. 1.3.3 The High Court. The Superior Courts Act 10 of 2013 came into operation on August 23, 2013. This act created a single High Court in South Africa, with various divisions constituted in terms of Section 6 of the said Act. In other words, Section 6 of the Superior Courts Act stipulates that there is only one High Court in South Africa, with the following divisions. Eastern Cape Division, with its seat in Grahamstown. Eastern Cape Local Division, with its seat in Bishow. Eastern Cape Local Division, with its seat in Thatcher. Eastern Cape Local Division, with its seat in Port Elizabeth. Free State Division, with its seat in Bloemfontein. Gauteng Division, with its seat in Pretoria. Gauteng Local Division, with its seat in Johannesburg. Gauteng Division, with its seat in Pretoria, but functioning as Limpopo Division, with its seat in Polokwane. Gauteng Division, with its seat in Pretoria, but functioning as Limpopo Local Division, with its seat in Thohoyandou. Gauteng Division, with its seat in Pretoria, but functioning as Mpumalanga Division, with its seat in Nelspruit. KwaZulu-Natal Division, with its seat in Pietermaritzburg. KwaZulu-Natal Local Division, with its seat in Durban. Northern Cape Division, with its seat in Kimberley. Northwest Division, with its seat in Mahikeng. Western Cape Division, with its seat in Cape Town. Each division of the High Court consists of a judge president and one or more deputy judge presidents. Moreover, each division of the High Court consists of as many judges as are necessary in accordance with the prescribed criteria and approved by the President. The High Court has original jurisdiction and can hear any matter which arises within its area of jurisdiction. The High Court is the only court that has jurisdiction to give judgment on the following matters: divorce proceedings, the status of a person in respect of mental capacity, applications for the sequestration of a person's estate, the liquidation of a company, and the validity or interpretation of a will. The High Court also has jurisdiction in respect of certain constitutional matters. For example, it may decide whether any fundamental right entrenched in the Constitution has been violated. 1.3.4 Other courts of importance in the Southern African context. Other courts may be important in the Southern African context because of their Roman Dutch legal heritage. Some of the judgments of these courts are also reported in the South African law reports. The Supreme Court, an appeal court, and High Court of Zimbabwe. The seats of these courts are in Harare. The Supreme Court, an appeal court, and High Court of Namibia. The seats of these courts are in Windhoek. 1.3.5 Officers of the Superior Courts. A registrar is appointed in each of the superior courts. The registrar and his or her assistants are responsible for the smooth functioning of the court. The registrar's duties include the issue of process, summonses, warrants, etc., the enrollment of cases, the issuing of orders of court, and the maintenance of records. A number of sheriffs are appointed for each of the divisions of the High Court. It is the duty of the sheriff to serve process and to execute judgments and orders of court. In some divisions of the High Court, there is a master's office presided over by a master. The master has various administrative and quasi-judicial functions mainly concerning deceased and insolvent estates, the liquidation and judicial management of companies, and the affairs of persons under legal disability, for example minors and mentally disordered persons. Brief mention must be made of legal practitioners. The legal profession in the Republic is divided into two main classes, namely, advocates and attorneys. The chief distinction between these classes is that advocates mainly appear in the Constitutional Court, the Supreme Court of Appeal and the High Court, whereas attorneys, apart from giving assistance in all sorts of non-litigious matters such as drawing up contracts and wills, mainly practice in the magistrates' courts. Moreover, an attorney can also be a notary, which means he or she can draw up and attest antenuptial contracts and other notarial deeds, and a conveyancer, which means he or she is entitled to prepare deeds of transfer of immovable property, certificates of title, mortgage bonds, etc. for registration in a deeds office. 1.3.6 Magistrates' Courts. Magistrates' courts are to be found in most towns in the Republic, but a magistrate has a very limited jurisdiction in comparison with that of the superior courts. A magistrate may not hear any of the matters which fall exclusively within the jurisdiction of the superior courts. The clerk of the court exercises more or less the same functions in the magistrate's court as does the registrar in the superior court, and the sheriff, previously messenger, of the magistrate's court has duties similar to those of the sheriff of the various divisions of the High Court. 1.3.7 Small Claims Courts. The small claims courts are intended to resolve minor civil claims in a prompt, affordable and simple manner without legal representation for the parties. Anyone, except juristic persons such as companies, close corporations and associations, may institute a claim. Sections 15 and 16 of the Small Claims Courts Act, 1984, provide that the small claims courts have jurisdiction to hear any civil matter to the amount of R15,000. It is important to remember that there are some matters that cannot be taken to the small claims court even if they involve amounts of R15,000 or less. Examples of these matters are divorces, matters concerning a will, malicious prosecution, wrongful imprisonment, breach of promise to marry. There is no magistrate or judge in a small claims court, since these courts' presiding officers are commissioners who are usually practicing advocates or attorneys who act as commissioners at no cost. The parties in small claims court matters are not allowed legal representation when appearing before the court, but advice can be obtained from paralegals. Attorneys, lawyers, may only be used to prepare a party's case. No appeal may be filed against the judgment or order of the small claims courts. However, the court proceedings may be referred to the High Court for review. Such a review will only be done on the following grounds: the absence of jurisdiction by the court, bias, malice or corruption on the part of the commissioner, and gross irregularity pertaining to the proceedings. 1.4 The doctrine of stare decisis. 1.4.1 Introduction. Doctrine of stare decisis. 1.4.1 Introduction. The judgments of superior courts are, as is evident from the above, one of the most important sources of the law. Consequently, their operation and effect on South African law must be examined. Theoretically, the function of a judge is to state, interpret, and apply the existing law but not to make new law. Nevertheless, the effect of a judicial decision which gives a new interpretation to a statutory provision, or which abstracts, extends or adapts a common law principle, is, in many cases, to create law. Law so created is termed judge-made law. Because a later court does not depart lightly from the decisions of an earlier court, this judge-made law becomes an established legal rule. The conclusion should not be drawn that a court or a judge purposefully sets out to create law. It remains the task of the judge merely to apply the law. If a judge is forced to conclude that the law is silent on the particular matter before him or her and that indeed no applicable principle exists, or that the statutory provision is manifestly wrong or completely antiquated, a new principle cannot be created, or an old principle replaced with a better one, however firmly the judge may believe this to be desirable. This task the judge must leave to the legislature. However, a principle of the common law can, in fact, be abrogated by disuse if it is no longer in accordance with modern views, and a judge may decide that such a principle no longer applies. 1.4.2 Application of the doctrine. Literally, the phrase stare decisis means the decision stands. Obviously, when a court gives a decision, the parties to the dispute concerned will be bound by the decision. But what is the effect of this decision on similar disputes which may arise in the future? Will the court, when it has to decide this new dispute, have to follow the previous decision, or will it be free to formulate its own principles and to ignore the previous decision? Take, for instance, a new act which has been passed by Parliament. It could happen that a dispute arises on the meaning of a certain word or phrase in that act. A court is called upon to adjudicate this dispute and it interprets the word or phrase in a certain way. Its decision is then binding on the parties who brought the dispute before the court, but what would the position be if the same word or phrase had to be interpreted later by another court? Strict adherence to the doctrine of stare decisis would mean that the later court would be bound by the earlier decision regardless of whether or not the earlier decision could be regarded as correct. This approach would lead to legal certainty, but it would sometimes be attained at the expense of a fair decision. At the other extreme, the view exists that each case should be decided on its own merits and that earlier decisions on the point in question should be ignored. While this approach would possibly lead to fairer decisions in some cases, it would also lead to legal uncertainty, which has grave disadvantages. Not surprisingly, South African courts observe neither of these extremes and follow a middle course in this regard. A court is bound by its own decisions unless and until they are overruled by a superior court. But it is conceivable that circumstances may arise which would render it possible for a court to override its own legal opinion. Such exceptional circumstances would be where the previous decision is clearly shown to be wrong. That court decisions are binding in this manner has never been laid down by statute. Accordingly, the rule of stare decisis is itself an example of how the courts operate to create law. Nowadays the courts are bound by earlier decisions simply because they laid down the rule of stare decisis in earlier cases and adopted it in subsequent judgments. As emerges from the above, stare decisis applies in South African law, but in appropriate cases it is possible to depart from the decision of an earlier, and even of a superior, court. 1.4.3 The doctrine of stare decisis and the hierarchy of courts. The position may be summarized as follows. Every court is bound by the decisions of the superior court within its area of jurisdiction, unless the decision of the superior court is based on so obvious an error, such as failure to take into account a statutory provision, that there can hardly be any difference of opinion on the matter. Thus, a division of the High Court, whether it is a full bench consisting of 3 judges, a bench of 2 judges or only of 1, is bound by the decisions of the Constitutional Court and the Supreme Court of Appeal. A bench of 2 judges is bound by decision of the full bench, and a single judge by the decisions of a bench constituted in either of the 2 ways mentioned above. Every court is bound by the decision of a court of concurrent status within its own area of jurisdiction, unless it is convinced that the earlier decision was incorrect, even though the matter may permit a difference of opinion. Thus preceded, the Supreme Court of Appeal is bound by its previous judgments, even a bench of 5 judges, by a bench of 3, unless persuaded that the earlier judgment or line of decisions was patently wrong. A full bench of the High Court is similarly bound by an earlier full bench decision, a bench of 2 judges by an earlier decision of a 2-judge bench, and a single judge by an earlier decision of another single judge. A departure from an earlier decision takes place only on very good grounds. One division of the High Court is not bound to follow the decisions of other divisions of the High Court, since they belong to different areas of jurisdiction. Hence, a single judge of the division of the High Court in Johannesburg is not bound to follow the decision of the full bench of, for example, the division of the High Court in Bloemfontein. Nevertheless, a court, no matter how it may be constituted, will not depart from the decision of another division of the High Court without good reason, since a great deal of persuasive authority attaches to such a decision. Magistrates' courts are bound by the judgments of the Constitutional Court, the Supreme Court of Appeal and the High Court. If the judgments of the divisions of the High Court are conflicting, a magistrate should follow the decision of the division of the High Court in whose jurisdiction that magistrate's court falls. In general, one magistrate does not necessarily follow the judgments of another magistrate, if for no other reason than that the judgments of magistrates' courts are not reported.